So Mr. Drew or Mr. Isles, either of you oppose that motion to amend the scheduling order?
Yes, Your Honor. I filed a response to the motion just indicating that the letters of representation or the letters for Crystal Gens being named the PR and continuing the PR for the estate, those were provided to defense counsel a while ago, and they've been available for quite some time. It's a matter of public record. In addition, the records from both the decedent's gynecologist office and her PCP, the authorizations have been provided. I don't know that that really adds anything or takes anything away from the case, but certainly defense counsel has that now to the degree that it wishes to use that to defend the case. I don't see anything else in the motion that they indicated they needed, and I request respectfully that we just move forward with what's next on the normal course of things, which would be final pretrial and then a trial.
Okay, Mr. Lobello?
Well, Your Honor, and I believe we disclosed this to the court, that some of the information that we sought to compel was provided. There was a partial withdrawal filed, namely as to the motion to compel, but there is outstanding information that we're looking for from the plaintiff's aspect in terms of what happened with Toyota. Toyota is a non-party to this case. I did receive some information from Toyota's counsel that was limited by the agreement between I and Toyota's counsel. However, what I'm seeking to obtain is whatever information the plaintiffs may have with regard to that issue with Toyota, given their position with regard to their experts saying that there is no malfunction with the airbag or the vehicle in general at the time of this accident. So in part with the motion to compel and without mingling the matters, Your Honor, that's the reason we're looking for further discovery. Also, as the court indicated previously, we have the deposition of Mr. McDonald coming up. I've sent Mr. Isles some proposed dates that I'm trying to confirm with Mr. McDonald to accomplish that within this month. And we're essentially just seeking more time, Your Honor. And then after that, I like to resume talks in terms of mediation. I reached out to Mr. Barney on Monday to inform him of what was going on as he asked for a status update, but that's the tentative plan thus far, Your Honor. And I suppose, without mingling the matters, maybe that answers some of the other questions that we have before the court today.
Yeah, thank you. So, Mr. Drew, what's your position on the discovery request?
There are no outstanding discovery requests to the plaintiff, as far as I know. There was a request that was ultimately turned over to an attorney named Bob Tyler and another attorney whose name escapes me. He represented Toyota. To my knowledge, that was all resolved to Mr. Lobello's satisfaction. I think the attorney for Toyota and Mr. Lobello reached an agreement. I saw evidence of that agreement in emails. I also saw evidence of compliance with that. That particular matter was not something that was ever filed. There was no litigation. It settled pre-suit. There were no expert affidavits and no expert testimony in that case. Mr. Lobello sought the amount of the settlement, which was given to him. He sought Toyota's understanding as to what the allegations were. He was provided with that. And he wanted to just see who the settlement was between. And he was given that information. So that is all that was requested, and I believe that's all been satisfied. I don't know, I don't believe there's anything else outstanding relative to that particular issue. And I don't know if Mr. McDonald, defense's expert, who's been ordered to provide deposition testimony because we couldn't get it otherwise, I don't know if he's going to address those issues or not, but I don't think we need to extend discovery just to have the deposition, which was court ordered, because it was properly requested during the course of discovery. So I think the dates are next Friday, the following Tuesday, and Wednesday. If those are the dates, we'll get that deposition done here in less than 2 weeks.
Okay, Mr. Lobello?
Your Honor, there was some mention, and this was during the recorded statement, I believe, that Mr. Drew was present for, or some discussions during his former representation with Mr. Smith, that Tim Robbins had done some work on this case, or was going to be retained to do some work on this case. So that's the discovery regarding Toyota that I'm looking for. And I understand that Mr. Drew is saying there was no affidavits or reports generated by any experts, but I just like the ability to investigate that matter, if the court would permit.
Is that the subject of an existing interrogatory or discovery request?
Your Honor, we had sent discovery requests. I believe it was in the week or weeks prior, maybe 2 weeks prior to the close of discovery in this case. Mr. Drew responded saying we don't have enough time to answer this, in an objection, and no response was provided in that regard. And that's when Toyota's counsel and I started communicating, and I did obtain some of the information that I was looking for, but again, I'm just trying.
The defense asked the court for more time, while the plaintiff argued that everything had already been disclosed. The dispute focused on a prior settlement involving Toyota, a company that isn't even a party to the case. Lawyers debated whether key information was missing or already available. After hearing both sides, the judge made a critical decision. Discovery would be extended, but no one would be forced to turn anything over yet. The court's message was simple: if you want more answers, you need to ask clearer and more specific questions.
To dot all the I's and cross all the T's here.
Your Honor, to be fair, and I don't mean to be throwing stones, I really don't. There was nothing in the discovery request that specifically sought anything about experts, anything about expert consultations, anything about Tim Robbins or his company. None of that was the subject of a discovery request. It's true that defense counsel sent, I think, literally days before the discovery cutoff, a request for information regarding the resolution or any sort of settlement with Toyota. We did object, as was proper under the court rules, saying, look, the court rules say you have to send it well enough of the discovery cutoff that there's time to answer. However, because I don't believe in just conducting business like that, I filed the appropriate response with an objection. However, I did also point Mr. Lobello in the direction of where he could get the answers. I said, unfortunately, Ms. Gens is covered by a confidentiality provision. Here are the attorney's numbers and here are their emails. Reach out to them and see if they will give you the information. I gave that to Mr. Lobello, and he followed up on that, and he got the information he sought. But there was not anything about Mr. Robbins. There was not anything about experts. And to suggest otherwise isn't really being completely candid, I guess I'm trying to say.
All right. Okay. Was there something else you wanted to add, Mr. Lobello?
Yeah, Your Honor, my discovery request was very broad in terms of what I was looking for, so to limit it in that respect, I think, is not accurately depicting what I had asked for in my discovery responses. But in any event, I understand. So.
All right. What I'm going to do is, I don't think at this stage of the case, I mean, I don't think there's any harm in extending discovery as requested under Michigan court rules. Discoveries should be broad and open process, and I don't think the case is so far along now that it would be unduly prejudicial or unfair to allow Mr. Lobello to look into what sounds like some pretty limited issues. So given the kind of the dispute over, the existing discovery request, number one, I'm going to grant the motion to amend the scheduling order and extend discovery as requested in the motion. The court is not going to grant any orders to compel discovery at this time, but what I would simply say is, Mr. Lobello, to the extent that you need to follow up with a more specific request, you'll have the time to do that. To the extent that you don't get sufficient answers or believe that you don't, then that could always be the subject of another motion to compel if necessary. So Mr. Lobello, if you can add that to the order that you're going to prepare as well. And then in terms of the status conference, I simply will set this for another status conference at the expiration of the extended period of discovery, and then we'll go forward from there. Mr. LaBello, anything else that we need to address today? From your
Nothing
side?
further on my end, Your Honor.
Mr. Drew,
No, Your Honor. Thank you for your time and your consideration today.
Mr. Oz?
No, Your Honor, thank you.
Okay. All right. Thank you. That's all for today, and everybody's free to disconnect.